2020 vote, the race for Montana Supreme Court.
Good morning and welcome to another special edition of Face the State on the Montana Television Network. I'm Mike Dennison, MTN's chief political reporter. As you know, we've been having debates each week for the last several Sundays between candidates for statewide office. This is our final debate on that series. Today, we have the candidates running for a position on the Montana Supreme Court. Justice Lori Mckinnon is being challenged by Helena attorney Mike Black. In Montana, judicial races are nonpartisan, so neither candidate is connected to a political party. First, we'll go over the rules of the debate briefly, and then we'll talk more about the candidates. The candidates will have questions directed to them by me. They'll have 1 minute to answer, and the other candidate will have 30 seconds to rebut. At the end of our debate, each candidate will have a 90-second closing statement. Now, let's hear more about the candidates. Lori Mckinnon was elected as a justice on the Montana Supreme Court in 2012. She grew up in Baltimore and has a law degree from the University of Baltimore. She began practicing law in 1987 as a prosecutor for the city of Baltimore. She moved to Montana in 1995 when her husband took a job with the Indian Health Service in Browning. She worked as a deputy county attorney in Glacier and Toole counties and was elected in 2006 as a state district judge in the 9th District in north central Montana. Mike Black grew up in Havre, attended the University of Montana, and earned his law degree from Cornell University in Ithaca, New York. He has more than 30 years of experience practicing law and working in public service, including at the office of the Montana Attorney General under Democrat Steve Bullock and Republican Tim Fox. He has also worked as a lawyer in private practice and for the Montana Legal Services Association, which represents low-income people in civil cases. The first question goes to Mr. Black. Mr. Black, I think a lot of voters are probably not that familiar with the Montana Supreme Court. Tell us why they should care who's on the Supreme Court and why they should choose you for that position.
Well, thank you for the question, Mike, and thank you for the opportunity to be here today. Hear about the Montana Supreme Court because it is the last place where your rights can be vindicated and protected. That the laws of Montana can be applied for the benefit of everybody, applied equally and fairly. The reason why I am the best candidate for this position is because of my 30 years of experience working on complicated cases, representing some of the poorest people in Montana, some of the richest people in Montana. And I believe in protecting rights guaranteed by the Montana Constitution and upholding established law. I believe that we should protect our rights to privacy under the Constitution, our rights to public access to land and water under the Constitution, and to protect the rights of consumers. So I believe that based upon my experience working on complicated cases, that I'm in the best position to determine hard cases on the Montana Supreme Court.
Thank you, Mr. Black. Ms. McKinnon, your response.
So first, Mike, you didn't tell everybody that I've been a justice on the Supreme Court for 8 years already. And that is in part my response. I've decided thousands of cases, written 500 majority opinions, 150 concurring, dissenting opinions. And the job of a justice on the Supreme Court is to review a district judge's decisions. And I've been a district judge, so I know where that district judge is coming from, and I have that insight. That's why I'm the best candidate.
The next question goes to Ms. McKinnon. Let's expand a little bit on your answer that you just gave us about why voters should choose you to serve another 8 years on the Supreme Court. As you said, you've been on there for 8 years. Why should they say, let's give you another term on the court?
The past 8 years has been a true honor to serve Montana. I have worked tirelessly and faithfully, upheld the Montana Constitution, a very special constitution, the constitutional rights in that, and followed the rule of law. I've certainly carried my weight on the court, as I indicated, 500, close to 500 majority decisions and another 150 dissenting and concurring opinions. And I will say that my oath is to the citizens of Montana. And so when I am convinced that the court has gone astray with respect to the rule of law or is not upholding a constitutional right, my position asks me to write those dissenting and concurring opinions. A lot of work, but work that I love, and it's work that benefits Montana in terms of, not only writing good majority opinions, but establishing areas of law that maybe we should be looking at, and there should be some evolution in the law.
Mr. Black, your response.
Well, I'll respond at first with respect to my qualifications. I've worked on some of the most complicated lawsuits in Montana over the last 30 years, and I've fought against some of the best lawyers in Montana during that time almost every day. It's my job in those cases to figure out the facts and figure out what the law is and what it should be. And I believe I can do that. If Justice Mckinnon, even though she has authored a number of opinions, she's also authored opinions that are dissents that are opposing public access to public streams and opposing the right to choose of women in Montana. And those are questions that I think are going to come up again and again.
Thank you, Mr. Black. The next question goes to you. Just taking up a little bit on what you just mentioned there. You've said that in your campaign that Justice McKinnon has made some decisions that show a political or personal preference. I'm just wondering, what decisions are you talking about? What could you point to that would back up this charge?
I think that Lori McKinnon was elected with the help of dark money because of her bias against public uses with respect to property. When public uses come up against other property rights, she has consistently ruled against property rights or public rights to use property with respect to access. The one case in particular involved the Madison County Ruby River public access case, where one of the dark money contributors to the Montana Growth Network, and I still have the flyer that came to the Black household in 2012, where they said that they supported Justice McKinnon because she would not vindicate private rights or would not vindicate public rights with respect to the property. And we all know that, Mr. James Cox Kennedy, who was a party to that case, never disclosed that he gave $100,000 to this dark money group. And my question to Justice McKinnon is, what did you do to find out who gave money to that group after you were elected?
Ms. McKinnon, I'm sure you'd like to respond.
Well, there's first of all, I'd have to say that was a 5-2 decision. I had no idea who the owner of the property was. I don't look at that when I decide a case. I look at the positions of the parties in terms of their arguments and what the law is. That was a straight up easement decision on prescriptive easements. It's never been cited for the principles that are in it. So and to suggest that my vote was bought by dark money, I had no association at all with the independent expenditures that came into the election in 2012. And Mr. Black is implying that my vote was bought as a sitting justice. That's a pretty strong accusation to make.
Thank you. The next question goes to Ms. McKinnon. Ms. McKinnon, you've been on the court for 8 years. You've authored or been parts of many, many decisions. I'm wondering if there are a decision or two that you would point to that really defines your judicial philosophy or your approach to the law and deciding what to do.
So I'd have to say the one that comes to mind right off the bat is the Espinoza decision, which just came back from the United States Supreme Court. I authored that decision. I believed that and had cited constitutional authority from Montana that the no aid provision to religious schools was absolute, and that Montana had a unique no aid provision that didn't allow any type of payment indirect. And so I navigated that decision through only Montana law. And through that very small amount of give between the first in the Establishment Clause and the Free Exercise Clause. And it was unique to Montana history and unique to Montana's Constitution. Unfortunately, the Supreme Court did not accept the Montana Supreme Court's views on our Constitution.
Thank you. Mr. Black, your response?
Well, I want to go back to the public access case because I had a question for Justice McKinnon she didn't respond to. And under the rules regarding judicial conduct, you're supposed to avoid the appearance of impropriety. So after you were elected and had hundreds of thousands of dollars of support from the Montana Growth Network, what did you do to try and figure out who were the contributors to the Montana Growth Network? So when they come in front of the court, as Mr. James Cox Kennedy did, you could address that because we know that he did not inform the court what he did illegally to help you get elected. That's the question I have.
Thank you. I'm going to divert a little bit from our format here and let Ms. McKinnon respond to that question.
So it's very important that we are careful about disenfranchising a vote. And what Mr. Black is doing is questioning the legitimacy of my 2012 election 8 years ago. Now, I won that election because in my mind, and I have had a lot of jury trial experience, presided over a lot of jury trials, and I'm always impressed with the common sense vote that they make. I won that election. I had the most judicial experience of either candidate, and I had the endorsement from the Billings Gazette, and I had no association with the dark money, no control over the independent expenditures, and I don't believe that I was elected through Montana Growth Network's injection of money into that race. I believe that the people of Montana understood who was the most qualified candidate. So I don't have to answer to why I didn't look up who was supporting Montana Growth Network at the time the case was made. I had no idea.
The next question goes to Mr. Black. Mr. Black, when I look at the campaign contributors, of course, this is a nonpartisan race, but I notice in your contribution, there are a lot of Democrats giving to you and other people as well. And the donors to Ms. McKinnon tend to be conservatives. I'm wondering if that's anything voters should consider when they're deciding who to choose here.
First of all, I don't know the political party of anybody who's contributed to my campaign. There's probably a couple of people who serve for public office who have contributed. But political parties have nothing to do with this. I am a nonpartisan candidate. I don't believe that your political or, personal biases should have anything to do with what you do on the court. Anybody who comes before the court comes there as a citizen of the state of Montana or from some other state. I fought under both attorney generals for free and fair elections. I fought actually for nonpartisan elections in judicial races all the way to the United States Supreme Court. So I don't think that who contributes to what campaign has any bearing on whether or not a justice would be partisan or nonpartisan. I think you should look at the particular justices or attorneys' record on the kind of cases they work on to figure out what kind of qualifications they have and what kind of justice they would be.
Ms. McKinnon, your response.
I'm not sure what I'm responding to, Mike.
Okay, so that's fine. The next question goes to Ms. McKinnon. Ms. McKinnon, you said during your campaign and that one of your principles is upholding the rule of law. What does that mean exactly? Isn't it a justice's job to decide whether the law is applied correctly?
So I think probably the best answer to that is to describe my judicial philosophy. The Constitution is the absolute goldstone to if you have a constitutional question, that's what's driving the inquiry. If a statute, for instance, is constitutionally challenged, then we have to look at whether the Constitution has been violated. If it has not been challenged constitutionally, and there's law applied to interpret it, then we're enforcing that statute because it's unconstitutional, and the rule of law then controls how we are looking at that precedent and what we are doing. So, I think that the first thing is always the Constitution, whether there's constitutional rights implicated. The second is following the rule of law so that we're consistent, and that we also recognize the significance of a collective body of thinking, which doesn't only include the court that we're presently composed with, but also the courts previous. And in that way, the structure of government and the judiciary protects against aberrant decisions, against large changes in the law, because we follow that rule of law.
Mr. Black, your response.
Well, I believe that two things that Justice McKinnon I firmly agree with. That is that on constitutional questions, the court needs to be consistent and that you need to follow precedent. And one of the things that is at top of mind right now is with the death of Justice Ruth Bader Ginsburg, what will be the result with respect to a woman's right to choose in Montana? And I want to assure women that if I'm on the court, it's settled law that under the Montana constitutional right to privacy, your right to choose will be protected. I don't believe that Justice Mckinnon shares that view based upon her dissent in the Weems case, but I encourage her to address that and assure the women of Montana that their right to choose will be protected under the Montana Constitution.
Thank you, Mr. Black.
From Roe versus Wade.
Mr. Black, the next question goes to you. Of course, in Montana, we have an overcrowded prison system. The court deals with lots of criminal cases, yet we still also have a crime problem in the state. What would you do, or what have you done to try to address these problems?
Well, certainly the position of Supreme Court justice is to make sure that with respect to trial court proceedings, that the rules of evidence are followed, that constitutional protections are followed, and that sentencing is legal. So my background is not in the criminal law. I think that Justice Mckinnon has a much more extensive background in criminal law, and I don't think that there's a lot of daylight between us on most of the decisions that she's made on the criminal matters. What I can say is, at least with respect to one troubling aspect of our system with respect to incarceration of folks, is that Native Americans are incarcerated at a far higher rate than most other folks in Montana. And I would assure that the people in the Native American community that growing up in Havre, on the north side of Havre, that I will be a justice who will be fair and make sure that with respect to prosecutions of Native Americans, that they are treated fairly in our system.
Thank you, Mr. Black. Ms. McKinnon, your response.
So first, I think I'm entitled to respond to the Weems case.
Yes,
and I would just quickly say that Weems was decided on the appropriateness of a preliminary injunction. We never got to the merits of the case, and that's why I, along with Justice Shea, and I can't remember the third justice, dissented in that case. So to stretch that into a discussion on women's right to choose and to say that I'm against is just more of what Mr. Black is doing in this campaign. So. And I'm sorry, Mike, if you could tell me what the last question was.
I'd be glad to rephrase that. I was talking about the criminal justice system and the overcrowding in the state prison, and I'm just wondering. We have a crime problem in parts of the state as well on many fronts. I'm just wondering, what have you done as a justice to try to address those problems, or was there anything you should do or shouldn't do?
Absolutely. I'm a judicial liaison officer with the ADA and NHTSA. One of the things that we're looking at in Montana is to more appropriately deal with the Native American population in drinking and driving cases by offering intoxilizers and ignition interlock devices so that they can get out of jail and be monitored. The Native American population, I'm involved with Justice Gustafson, looking at exactly what those numbers are in terms of increased incarceration and basically ensuring that Montana addresses issues of equality of justice, because you have to have the data before you can make the move. And so we're looking at that data now to address it.
Thank you.
Okay.
Mr. Black, anything you want to add to the subject at all here at this point?
No, other than she didn't answer my question with respect to a woman's right to choose, whether it's settled law based on Armstrong or not.
I firmly believe, and if Mr. Black had judicial experience, he would know, you never make a decision based on, you have to look at the case that comes in front of you, review the arguments. There's always nuances to everything. And I would never say how I would rule in a case in the future, other than to say I would follow precedent and consider the arguments of counsel.
The next question goes to Mr. Black. Mr. Black, you said that Montana has a unique state constitution. I'm just wondering, when you say that, what do you mean? What are the rights in there that you think makes it unique? And what would be your role as a justice in protecting those rights if you choose?
Absolutely. There are a couple of things. The right to privacy in Montana is unique with respect to versus federal law, because the right to privacy and the Armstrong case in Montana are settled law with respect to the right to choose, and I will honor settled law. The right to a clean and healthful environment is stated twice in the Montana Constitution. That is unique in Montana. It's part of the fundamental rights, and it's also part of a later section in the Constitution with respect to government action. I think that based upon my many years and deep history with the state of Montana as being a student of history, I think I understand why the provision for the clean and healthful environment is in the Constitution. The right to dignity is in the Constitution. I believe that that's something that's also unique to Montana. Those three things in particular, along with the right to public access of waters and lands that are in public hands, are important rights that I believe I am qualified to help protect based upon my background in Montana and in the law.
Thank you. Ms. McKinnon, your response.
So we have a very special constitution. We have protections that are enhanced above that of the federal constitution. And the right to clean and healthful environment is a case that is going to be argued next week before the Supreme Court. And we will consider that constitutional provision probably for the first time. The right to privacy is as well an enhanced right in Montana, and also the right to know versus the right to privacy and the court's role in balancing those competing constitutional rights on occasion.
Thank you. The next question goes to Ms. McKinnon. Ms. McKinnon, do you think that Montanans have equal access to the courts in Montana? And is there anything that you have done to try to achieve that goal if they don't?
So I don't think you can ever do enough to provide access to Montanans for the courts. And yes, I have. I've worked very hard in establishing a court-connected mediation program that is income eligible, meaning directed towards low-income parents that need parenting disputes resolved. It's always a better outcome to have a mediation proceeding and for the parents to invest into that decision-making process and decide what's best for their children, rather than have a court proceeding where the judge, who's unfamiliar with the children and the parents, makes the decision. We've gotten that off the ground in Flathead County. COVID has had some issues and presented some difficulties in terms of the mediation process. We want to get it going in Lewis and Clark, but it is a court-connected program, and we have guidelines and standards that were adopted over a long process to ensure mediation was done correctly. But access to the courts is a huge issue.
Mr. Black, your response.
Well, I certainly believe that access to justice for people without means is an important issue. But I also think that when people of Montana bring a lawsuit in court, that they should be able to pursue that lawsuit. And there are a number of cases, which I've outlined in some of my campaign material, where Justice McKinnon rules against Montana people and Montana consumers in favor of out-of-state interests or out-of-state corporations and deny them the opportunity to prove their case in court. That is a problem. I think that those rights should be vindicated, and Montana people should have.
Thank you, Mr. Black. This will be our last question for the debate, and then we'll go to closing statements. Mr. Black, this question goes to you. The Montana Supreme Court, among some, is considered to be a liberal court that may grant more privileges to or expand liability and be more prone to help plaintiffs in cases. I'm wondering if you agree with that assessment, and what would your addition to the court do in terms of affecting that?
Well, I certainly don't believe that the court is tilted one way or another versus plaintiffs and defendants. I think that the court is not liberal in that sense. I think that right now on the court, we've got a number of justices who have spent a lot of time working for the government over their career. What I bring to the court is somebody who has fought it out in the trenches against some of the best lawyers in Montana and outside of Montana. In the civil arena, I've run my own law firm. I've paid the bills, I've paid the staff. I know what it takes to get that done. There's nobody on the court that has the type of civil litigation background that I have on complicated cases. That's what I'll bring to the court. I don't think it's a liberal versus a conservative issue. I think it is an issue with respect to understanding complex legal issues, having good instincts for the law, and working hard to figure out what the law is or what it should be. And I think—
Thank you, Mr. Black. We're getting a little short on time here. Sorry, I have to cut you off there. Ms. McKinnon, your response.
So I think it's telling that I have counted 5 cases Mr. Black has had over his career in the Montana Supreme Court. And, that's published, non-published. So when we talk about all of our vast experience, I'm not sure that that's quite accurate. A judge has vast experience because they handle everything that comes in. And I have handled and decided cases involving very complex civil litigation. I've
Thank you, Ms.
actually been the one
McKinnon.
making
We're
the
going to go to
decision.
closing statements now. Sorry about that. Now we're going to closing statements, and the first person to give the closing statements will be Justice McKinnon.
All right, thank you. Well, thank you, Mike, for doing this. There we go. But I want to thank the citizens of Montana, first of all, for giving me the honor and the opportunity to serve on the Montana Supreme Court for 8 years, and prior to that as a district judge for 6. It's truly an extraordinary opportunity to be able to do something you love, something you cherish, have a passion for, and something you're good at, while also serving the citizens of Montana. In 2012, I'm a much better justice now than I was in 2012, and that experience is what matters. I'm not a political person. I'm not a politician. I have never contributed to any campaign, and I think that fair and impartial nature is absolutely critical to a justice on the Supreme Court. We have a constitutional right to a fair and impartial judge, in addition to many other special rights in the Montana Constitution. And that fair impartiality as a constitutional right is absolutely the basis for the checks and balances and keeping the independent judiciary that we have. We cannot have partisan decisions made in the judiciary. Those partisan decisions have to be made in the executive branch and the legislature. By their very nature, they're partisan. We protect the Constitution and the rule of law. I took an oath in 2012 to do that, and I will continue. And I did it for 8 years. I want another opportunity to serve Montana for 8 more years and carry out that mission.
Thank you, Ms. McKinnon. And now the close of Mike Black.
Thank you, Mike, and thank you, Justice McKinnon, for this opportunity and the people of Montana. I think the people need to ask 3 questions before they cast their vote. First, who is Mike Black? Why is he running? And why should I vote for him? First, I come from a long line of folks in Montana. I've been here for over 100 years. I understand Montana. I come from homesteaders and railroaders. I worked for the attorney generals of both parties. I'm a nonpartisan person. I've worked hard for everything I've ever achieved, and I'm ready to work hard for the people of Montana. Why am I running for this office? It's because Justice McKinnon last year said that she was going to retire and move to North Carolina. And a number of prominent lawyers and judges encouraged me to run. Justice McKinnon, in fact, bought a home in North Carolina on 30 acres. According to a contract that's publicly recorded, she promised that she would live there for at least a year and only recently put it up for sale. I'm not going anywhere. I have worked hard on complicated cases for my entire career. I understand what hard work means, and there's nobody on that court who will outwork me. I have been endorsed by 5 retired Supreme Court justices, and a number of other retired judges and justices support my campaign. Why? Because they know my history. They know Justice McKinnon's history. I think they're in a unique position to judge who should be on the court. I would appreciate everybody's vote, and I want everybody who has a question to contact me directly if they have any further questions. And thank you for this opportunity.
That wraps up our show for this morning. I'd like to thank you for joining us here on Face the State. We've been having a debate between the Supreme Court candidates, Justice Laurie McKinnon and Attorney Mike Black. I'd like to thank them both for joining us this morning, and thank you for joining us on Face the State. I'm Mike Dennison for the Montana Television Network.